Well, hello there, and welcome to the latest edition of the Employment Law Show. Good to have you along, hopefully for the entire 30-minute ride. I'm John Scholes, Lior Samfiru there as well, employment lawyer at employmentlawyer.ca. Always reach out to Lior with any concerns. Got a great crew with him as well. I'll throw the phone number at you for the first time within the half hour. We'll repeat it, of course, 1-855-821-5900 and help at employmentlawyer.ca through the email. Also a website available, free to you anytime, of course, anonymously to scope through it and have access to the severance calculator. Used to be a standalone website. Now it's rolled into pocketemploymentlawyer.ca. Lior will be using that a little later on in the show. And we always have a main topic this week. We're going to cover 5 myths about termination for cause. 5 myths about termination for cause. Some phone calls from our own radio shows. We got a whole basket of stuff to get through, Lior. We'll always get to that, and we will continue to do so. But we always start off with the case of the day or something that you want to talk about. What do you got this week?
Great to be here, John. Great to be talking about employment law to help demystify this topic. This is such an important topic. You have a job. I know you do. I have a job. We all have jobs, and we need to know our rights. It's not always obvious what our rights are. It's a lot of misinformation out there. We're going to be talking about myths later on today. I'll give you some examples of that. But if you go online, try to figure out what your rights are, you may be falling down to, or coming through a trap and you're not actually going to get the information that you need. Not on this show. On this show, we'll tell you what you need to know, what your rights are. We'll help you understand what to do if you're facing a workplace problem. We'll give you that power back. You may not think you have the power. Well, you'll get that power back right now on this show by knowing your rights, knowing what to do if your employment is terminated, if your boss is not treating you properly, if you're being discriminated against, if you're being suspended from work, if you're not getting paid properly. I can go on and on. We try to cover as many of these topics on every show. But if we can't get to your topic, your question, your issue, easy to reach out to me by phone or email. Don't hesitate to do that. But let's start off with the situation that came across my desk very recently. I spoke with a lady who got some troubling news from her employer. Now, this lady had worked for the same employer for over 12 years, and she doesn't drive, doesn't have a driver's license, but she didn't need to. Why? Because she had a bus right in front of her house that took her to work. It was a very short ride. She's been doing this for years, same bus back home every day, Monday to Friday, no problem. Well, wouldn't you know it, the news that she got from her employer is, hey, we're relocating. Much nicer facility, the employer says, but it's about 15 kilometers away. Not that far, really, but for her, that was disastrous. Why? Because she can no longer take this bus. You would have to take probably 3 buses. It would mean instead of taking 10 minutes to get to work, it would probably be an hour and a half to get to work. Again, she doesn't drive. So she talked to her employer, and they said, well, sorry, I mean, we're moving, so there's nothing we can do. And if you can't get to work, I guess you'll have to resign. She called me, and she wanted to understand her rights. Well, guess what? It is not a resignation. What her employer is doing is changing the terms of her employment significantly. She had a job where it took her 10 minutes to get to work. Now it's going to be an hour and a half. Not the company's fault, but certainly not her fault either. So because of this change, if she doesn't do it, and she won't, she can consider her employment as being terminated. Constructive dismissal is the term here. By changing the job, the terms of employment, it's as if the company let her go. She's now going to be owed severance. She's been there a while. She's easily going to be owed a year's pay, 12 months' pay. So I'm going to help her get that. But there's an important reminder there for all our viewers. If you're relocating, and because of that relocation, it's going to take you a lot longer to get to work, let's say an hour or more, in addition to what you were doing before, that could easily be a constructive dismissal. That may be the type of change you don't have to accept. And if your employer imposes it, you may be able to say constructive dismissal, not doing it, but guess what, employer, you have to pay me severance. So now you know what to do. If that's your situation, call me.
It kind of sounds like, Lior, 15 kilometers doesn't sound like a big deal for anybody who drives, for that matter, but it's almost sounding like when it comes to constructive dismissal, when they move the workplace, it's not a matter of distance, it's a matter of time, right?
It's all about time. Doesn't matter if they moved 100 kilometers or 2. The question is, how does that impact you? If because of this change, you're now going to take a lot longer to get to work, constructive dismissal. If the change is far, they moved far away, but it's not really going to impact you that much. You drive, it's going to be fine, that it's not a constructive dismissal. If it impacts you significantly, and by the way, John, it doesn't have to be a relocation. If anything your employer does impacts you significantly, that could easily be a constructive dismissal.
Would it be pushing it to say, you know, I'm assuming she's not digging ditches or roofing at this particular place. Say it's an office job, she's on a computer. Is it pushing it to ask for some sort of accommodation? I know it's not medical, but saying, look, I love working here, but if I can work from home, it'll save me the hour and a half getting to work. I can maintain my job. Will the employer say, we don't have to do that?
Well, here's actually what we're going to be trying to do here. I'm going to contact this employer and I'm going to say, you have to pay your 12-month severance because of this relocation, but we'll give you option B here. She can continue working from home, and if you allow that to happen, she'll continue working, she can do her job, and you won't have to pay your severance in that situation. So that's going to be an option, but if her employer says no, they don't have to, what they will have to do is pay severance.
Or Monday to Friday, she comes in, she works to home 3 days a week, some sort of compromise when it comes to that? Possible?
If she's okay with it and they're okay with it, there's no limit to what you can do. But ultimately, if the employer says it's come in or bust, that's a constructive dismissal.
Employmentlawyer.ca, where you want to go to catch a radio show near you in your market, specifically here in the GTA in Toronto as well. Lior and I do it every week, all week, and been doing it for years. Got a lot of great phone calls on the show. We play them back here because it's always a learning tool. So we'll get to our first phone call for the show right now. Listen up.
I was just fired. I'm 56 years old. I joined the company 8 months ago. 3 months into my position, I got into a car accident in a company vehicle. I sustained a major concussion. The big boss calls me in and fires me for poor performance. They're giving me a week left of my benefits. They're giving me 1 week severance. I don't know if I'm entitled to more.
And what kind of a job were you doing there?
I was a construction superintendent.
That actually doesn't sound outlandish for an employer to do that. You smacked up our car, you're out of here. Like, you're done, right?
Well, ultimately, the question is that cause? And it may not be cause, but there's a different issue here. They're saying poor performance. Is that performance because of his medical condition? He suffered some injuries. You cannot be let go because of your injuries. So there could be a human rights violation here. It's a huge problem. The other thing is this employer may think, well, he's in construction. Construction people don't get severance. False. Construction employees do get severance. In fact, severance is going to be calculated based on the same terms, age, position, and length of employment. So yeah, this person is likely owed severance, even in construction, even after only 8 months. His employer is saying, we'll give you a week's pay, we're going to be generous. Nonsense. It's not correct. He's owed more. So for the first time today, let us find out how you can also determine how much you're owed, how much this person is owed. We're going to go and use our severance calculator tool. You can find that, of course, at pocketemploymentlawyer.ca. Let's do that right now, and let's see how much severance he should be getting. So we know he's 56 years of age. He's been there for 8 months. Company says a week's pay is all you get. No, no, no. You see right there, he's owed as much as 6 months' pay, anywhere from 3 to 6 months of severance. And yes, that's true, even after only working for 8 months. That's how it works. You can do that yourself. If you worked for 8 months, 20 years, any other time, if you lost your job, or if you just want to know how much you're owed, go to pocketemploymentlawyer.ca, click on the severance calculator, and find out.
There's phone call number one. We appreciate that if you phone that in at some other date on the show. Phone call number two. Lior's coming up right now. Let's listen up.
So you accept a job and you accept a contract that restricts your severance because you don't want to rustle any feathers. You want to get the job. After a year, one decides, you know what, I think I want to mention it, whatever. And they say, well, we'll look into it. And then say maybe a month later, one is let go. Can they get their full severance regardless of the restriction in the contract?
So what employers often try to do, they listen to the show as well, they watch the show, and they realize, wait a second, we have to pay a lot of severance. So one of the ways we can try to get around that, employers may say, is by having the employee sign an employment agreement that limits their future severance. So the effect of signing an agreement that limits that severance could be disastrous. It could cost you tens of thousands of dollars, maybe even hundreds of thousands of dollars. But a few things. Number one, you can negotiate those terms. It is quite possible to negotiate that out of the employment agreement. Talk to your employer at the time, and oftentimes you're able to negotiate it out. But here's something else. In many of these cases, even though you may have signed an employment agreement that tries to limit your entitlements, it may not do so effectively. Probably 80%, 3/4 to 80% of the time, when someone did sign an employment agreement that tries to limit their entitlements, it doesn't really do that. It's not drafted properly to do so. So there's still a good chance that even if you sign that employment agreement that tries to limit your severance, you're still owed your full severance. So what does this all mean? Very, very simple. If you lost your job, doesn't matter if you signed an employment agreement that tries to limit your severance, doesn't matter if your employer is saying, no, because of what you signed, you're not owed anymore, you call me. Very good chance that despite what you've signed, you're still owed your full severance.
And how about, Lior, for the employers, as you say, who watched this show and tuned in and figured, oh, you know what, that could be potentially financial bad news for me. I'm going to rework some employment contracts, which I've never had or maybe haven't had for a while with my employees, and send them all new ones, people who are currently working there. How does that work?
So an employer may often say, well, wait a second, let's just have a person come in Monday and sign a new employment agreement. Can't do that. Doesn't work that way. For an employer to have a valid and enforceable agreement with an employee that's already working there, they have to give them something in return for signing. If they just sign, it's meaningless. It doesn't mean anything. On the other hand, if the employer says, hey, we want you to sign a new employment agreement, so we're going to give you a signing bonus or a pay raise or extra vacation, something extra that you wouldn't otherwise get, then it's enforceable. But for the employee, don't fall for that, okay? That $500 signing bonus may not be worth losing $50,000 in future severance. If your employer comes to you and wants you to sign a new employment agreement, don't do that without talking to me first.
And if I'm an employer, Lior, can I simply go to Google? Because, you know, Google has everything. You can buy cufflinks, you can get avocado toast recipes. Why can't I just get an employment contract off of Google and have them sign that? Right?
Now I'm craving avocado toast. Thanks for that. No, Google is not the friendly place, the right place to go to get an employment agreement signed or created. You need to get professional advice. Call me. I draft these all the time. To get something off Google is a waste of time.
Okay, third phone call is coming up after the break, and 5 myths of termination for cause on the other side of that break as well. We'll continue. In the meantime, the number to always reach Lior, 1-855-821-5900, help@employmentlawyer.ca. We're coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show. Lior Samfiru, John Scholes. Reach out all the time, anytime. Don't make a move until you make that phone call and back it up with an email. How about that? 1-855-821-5900. help@employmentlawyer.ca. We'll get to our main topic here momentarily, Lior, but phone call number 3 from one of our radio shows. As promised, let's listen up and get into it.
I had arthritis in my neck. I went up to my employer. I told him I had pain. I went to my specialist. He told me I'm suffering from arthritis in my neck, and I had to go get cortisone shots in my neck. So when I went back and told my employer I only could work a few days a week so that way I can alleviate some pressure from my problem, he deemed me not fit, and he let me go.
And how long did you work there for?
I've been with the same employer for over 15 years.
Well, the unfit part's right, but letting him go is not right.
That's the thanks he gets after 15 years of service. No, I hope, John, that our regular viewers know that this is illegal and they know what I'm about to say. So this person has a medical condition, okay? Not his fault, arthritis, it can impact his job. So what happens here? What happens is he needs to be accommodated. If there is work that he can do, just with support, maybe changing some of his hours, some of his responsibilities, maybe providing him with extra support, he could do his job with that, then the employer must provide that support. The employer doesn't get to say no, doesn't get to say we don't want to. They have to provide that support. We have human rights laws because of that reason. So right off the bat, that's the issue. Now, let's say the employer wants to, tries, but there's just no way to accommodate. They've tried, they've looked, you can't. Well, what happens then? He goes off on a medical leave, and hopefully at some point either he gets better or the company at some point is able to accommodate. What they cannot do is let him go. It's illegal to let you go because of your medical condition. It's illegal to let you go because you need accommodation or because you need some support and help from your employer. There's many things that can be done, accommodation being the main one of them. So this is a human rights violation. It's a wrongful dismissal, you name it. If your employer won't accommodate you when you're sick, when you have a medical condition, when there's support that you need, you call me right away.
And this one's not a big stretch anyway. It's not a huge accommodation, really.
It would be.
No.
The employer should absolutely be able to accommodate. But again, even giving the employer the benefit of the doubt, they really tried, they looked, they were making all the efforts possible. There's just nothing. Okay, let the person go off on a leave. You don't let him go because he's sick. That's always going to be illegal.
All right, let's get into this, Lior. Main topic for the show this week, 5 myths about termination for cause. Number 1, a single mistake, one only, justifies termination for cause. Out the door.
So let's start with the idea, John, that a termination for cause is the death penalty. It's the capital punishment of the employment relationship. Why? Because it's reserved for the worst offenders. It's only if someone does something terrible that they can be let go for cause and therefore not get their severance. It doesn't matter if they've done something wrong. That's not enough. So what the law says and what our courts have said is one incident of misconduct is almost never going to be enough to be cause. So maybe you did something wrong, you made a mistake, clearly you were not, you were in the wrong. That does not mean you can be let go for cause. That does not mean you can be deprived of your severance. If your company wants to let you go, they'll have to pay you your full severance. Now, of course, John, there's going to be exceptions to that. If you stole, but just one time, guess what? That's going to be cause. If you hit somebody, if you committed fraud, yes, even one incident of misconduct will be enough for cause. But beyond that, no, one incident is not going to be enough. The fact that you did something wrong does not mean you can be let go for cause.
All right, termination for cause myth. Number 2 is this, what I do outside of work can't ever lead to termination for cause. I love this one.
That is wrong.
Yep.
And it's easy to think, hey, whatever I do on my time is my business. How can the company hold that against me? How can they punish me or discipline me because of what I do on my own time? Not so fast, not true. If what you do on your own time can impact your employer, can impact your employer's reputation, their business relationship, the relationship with other employees, you can be disciplined for it. So to give you an example, let's say on your own time, on your own social media, you post racist, sexist remarks. Well, guess what? If you can be identified as an employee of that company now may be viewed badly by its customers, by its clients, etc. Those employees may not, your colleagues may not be comfortable working with you, so that impacts your employer. So yes, your employer could absolutely do something about that. Bottom line also is this, there's no such thing as privacy in terms of online activity. Right. If you do something online in your social media, assume that someone is going to see it. And what you do on your own social media, on your own time, can impact your job. So be smart about it. Don't do something that you don't want your employer to know about. If you do, that could be held against you. Does
that include something in the real world? You caught doing something really stupid on the Jumbotron at a Raptors game. You're wearing a company T-shirt. I mean, you've hit all the wrong marks, right?
You know, that actually has happened. Yeah. That's happened. Someone gets caught, on the news during a baseball game doing something bad, saying something bad. Guess what? Bad idea, especially if you can be identified as an employee of a certain company. That's going to make the company look bad. And yeah, you may be able to be disciplined for that.
Termination for cause. Myth number 3 is this, resigning is always better than being fired for cause, right?
Wrong, wrong, wrong. Now, listen, let's be clear. If you stole from the company, you're going to be terminated for cause. If they're going to let you resign, sure, may as well, because you're not going to get anything anyway because you stole. But keeping in mind what I said, because it's so difficult to terminate for cause, most of the times when the company tries to do so, they don't really get to. That's a wrongful dismissal. They owe you severance. What a company may often do is say, employee, we're going to let you go for cause, but resign instead. Not a good idea because you're foregoing severance. You're giving your employer a present, which is your severance. So don't resign unless it's voluntary. It's not better to resign than to be let go. It's better to be let go because you get severance. You get EI, which could pay you for a year. That severance could be for 2 years. So no, that's a myth. That's wrong. It's not better to resign.
Well, you did mention the word severance, Lior. Myth number 4, I can't get severance pay if I'm let go for cause.
you can and you will if the company pulled the trigger on a termination for cause before they should, which is frankly what happens in most cases. Most of the time when the company tries to terminate for cause, they don't have it. What you did is not bad enough to be deserving of the capital punishment of the employment relationship. And if the company doesn't have you at cause at 100%, they don't have you at all, which means they have to pay severance. John, 90% of the time, when I speak to someone that supposedly was terminated for cause, it's not cause, and they're owed their full severance.
All right, pal, fifth and final myth about termination for cause, and this is where people really stumble and even forget to pick up the phone or don't bother, and that is it's nearly impossible to challenge a termination for cause.
It's not impossible. It's easy, keeping in mind that the company has to prove cause. The employee doesn't have to disprove it. You don't have to prove that you didn't do something or that the company is wrong. The company has to prove it. So because they have to prove it, it makes it easy. Don't be afraid of the legal process. Don't be afraid of calling me. If the company says that they're letting you go for cause, you don't get any severance, you call me. Chances are you'll get severance, and it won't be that difficult to get anyway.
All right, good stuff. We'll take a short break here, come back with some emails, some questions, and employment rights rapid fire to wrap up the show as well. That's straight ahead, so stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Employment Law Show. Some quick contact information before we roll on here with more of your questions. To reach Lior and his team, phone number 1-855-821-5900. Help at employmentlawyer.ca and the website pocketemploymentlawyer.ca. Let's get to a question, Lior. This, by the way, is from terminationquestions.com. Free and anonymous website for you to use anytime. And it goes as follows. I worked as a financial analyst for 10 years on an indefinite contract. The company switched me to a 3-year fixed-term contract with no added benefits and then extended it for 2 more years. Now they're terminating me without severance, claiming I'm a contract employee. I'm almost 50. Where does that land me? What do you think? A lot of math there.
A lot of math, yeah. Carry the one, think about the numerator. No, but here's what I'm going to say without getting too technical, because there's various reasons as to what I'm about to say. In many of these cases, when the company changes your terms of employment, changes the way they classify you, ultimately it doesn't matter. It's very difficult to get rid of someone's seniority. So this person had been there for years, 15 plus years, and the company at some point said, you're a fixed term contract, now we're extending it, now we're letting you go. Chances are, in a case like this, after 15 plus years, he gets severance for 15 years. And the company doesn't get to avoid that by trying to call him something else, a contract employee, a fixed term employee. It doesn't work that way. And there's various reasons for that. So this person has been let go. Regardless of the reason, severance has to be paid. So the last thing we have to do, of course, is figure out how much severance he's owed. For that, we're going to go once more to our severance calculator tool. You'll find that at pocketemploymentlawyer.ca. Let's plug the information in and let's see what we have. So we know that this person is 49 years old. He's an analyst, been there for 15 years. Company says, well, because of your contract, we're not going to give you anything. No. You see right there, he's owed as much as 18 months severance. 18 months. It's a massive difference between nothing and 18 months. That's why you go to the severance calculator. Of course, if I didn't say it before, it's free and anonymous, so check it out.
You want to catch Lior and his team on the live stream they do every week, Facebook, YouTube, LinkedIn, at stlawyers.ca. Here it is. I've worked with my current employer for over 3 years. They recently closed, and a new company absorbed all employees. The new company issued contracts, changing job titles and duties while cutting benefits and vacation time. I'm not sure what my rights are.
So this could be actually a bit more complicated in a situation. If the company closed, were they in bankruptcy? If they were in bankruptcy, you may not be able to do anything. On the other hand, if they simply sold the business to another company, then yes, you're going to be owed severance if you choose not to accept, given the fact that the new company changed the terms of employment. So bottom line is this: if you're dealing with an employer and that employer is closed, shut down, sold their business, but you now have an offer from the buyer, if that offer is different, vastly different, either different hours, different pay, different responsibilities, compensation is not the same, you may be able to consider this situation as a termination. Despite the fact you have an offer on the table, you may not have to accept that offer and still get your full severance. But because always the devil's in the details, I don't want you to do anything. I don't want you to say yes, no, sign anything. Don't do anything like that without speaking to me first. These things can get tricky, but know that you do have rights, even if your business, your employer, has been sold.
Now, my follow-up question quickly, Lior, for those that are just watching the show maybe for the first time. If this doesn't affect me personally as an employee all that badly, can I take it for a bit of a spin first, try it out, and then say, you know what, this doesn't work, I don't like it?
So you really, if it's a sale of a business situation, can't do that. So if the new company takes over and they want you to sign and you do, you can't tell them, I'm going to only do this for a little while. On the other hand, in another situation where your own employer is saying, hey, I'm going to change your hours, your pay, you can tell your employer, I'm going to try it for a little while, see how that works, but then I may still come back and tell you, no. You may be able to do that. But if it's a new company as a result of the sale of a business, you always have to make a decision. Do you accept the offer given to you, or do you don't accept it and get your severance instead?
And always be smart. Reach out to Lior either way. Whatever your decision, before you make it, always reach out to Lior. Want to get in this final section for the program. That is the Employment Rights Rapid Fire. That is coming up right now. Listen up. Okay, rapid fire questions. Let's get rolling. Lior, number one, are all employees entitled to overtime pay, OT?
No, not all employees are entitled to overtime. There are exceptions. For example, certain professionals, doctors, lawyers, accountants, managers also are exempt from overtime. But beyond that, most employees are entitled to overtime. Even if you're on a salary, okay, you are entitled to overtime. And if you work overtime, you have to get paid in Ontario. That's if you work over 44 hours a week. Anything over is time and a half.
Rapid fire question number two. Can you refuse work you believe is unsafe?
You can, you should. Forget that. You must refuse work that's unsafe. You can do that and should always do that. Nothing is more important than safety. You can never be punished for refusing unsafe work. Your employer has to deal with that, bring an inspector if they have to, and never punish you for refusing.
Rapid fire question number three. Lior, does your employer have to give you advance notice of your termination?
They do, or they can pay you in lieu of that notice. Sometimes we refer to that as severance. So an employer has to give you a certain number of months or weeks of notice or payment in lieu of that. So severance, sometimes we call it pay in lieu of notice. That's what the severance calculator is there. You can find that at pocketemploymentlawyer.ca. But one of those two things must happen.
And it's free and anonymous, by the way, Pocket Employment Lawyer and the Severance app used by millions. Number four, is an employee able to take a leave of absence to deal with a family emergency / family care?
Absolutely. Under the Employment Standards Act, you have the right to take a job-protected medical leave in certain situations, which means for that period of time, your job is protected, your employer can't let you go, has to bring you back to the same job, same pay. And if your employer refuses, you can file with the Ministry of Labor, you can call me, but that's something you're allowed and entitled to do.
Final rapid-fire question for this week, Lior, is this: can an employee be fired for reporting on bullying in the workplace?
Absolutely not. You should always report to your employer if you're being harassed, mistreated, bullied in the workplace, knowing that no matter what the result is, you can never be punished. Your employer cannot do anything to you. That's something very important to keep in mind.
All right, got it all in. We're out of time. We got to leave, but I always give you the contact information before we slide out the door. The number to get a hold of Lior and his team, 1-855-821-5900, help@employmentlawyer.ca, and we'll catch you next time. Thanks for watching.